Hi, everyone. This is Stephanie Bivens with Bivens and Associates, and I'm one of the attorneys here at the firm. Thank you so much for joining us today. We're going to be talking about estate planning and specifically wills and trusts and how you determine which estate planning tool is right for you. So I'm going to hit share screen while we're getting a few more people I know are registered are getting ready to join us here. A few housekeeping notes. We're scheduled to go for an hour. We may end a little bit soon, depending on questions. I'll make sure that we can answer all of your questions during our presentation today. If you can use the Q&A feature of the webinar and submit your questions through Q&A, we'll be sure to address them as we go along, or we may hold off and address them at the end of our session today, but we will get to all of them. We are here to provide this information, and we do really appreciate you joining us. So let me hit share screen, and we will get underway here. Again, this is Stephanie Bivens, and we appreciate you joining us. If you have any questions today, please put them into the Q&A, and we'll address them as we go. We are going to be talking about the topic of estate planning, and specifically wills versus trusts, and how to determine which of these estate planning tools is going to be best for you and your goals. So, little about the firm. Bivens and Associates is a boutique law firm here in Arizona, and we help individuals and our clients with estate planning, probate, trust administration, business entity formation, elder law, special needs planning, guardianships, conservatorships, and long-term care planning. And we've been serving Arizona now for over 19 years. Little bit of background about me for those of you who I have not met yet. I am an Arizona native, but went to both ASU for undergrad and my law degree, and I am a certified elder law attorney through the National Elder Law Foundation. I do practice here in Arizona, and I serve on several boards that specifically do serve families and seniors here in Arizona. And I've personally been in practice for over 25 years now. But it's not just me, we do have a whole team here. So estate planning, when we talk about wills and trusts, those are not the only tools or legal documents that we use in an estate plan. So I want to talk about first all of the documents that you really do need to have in place to have a complete plan. And those are going to be medical directives. In Arizona, that is a healthcare power of attorney, a mental health power of attorney. Those documents simply designate someone that you know, like, and trust with the authority to direct your medical care and treatment in the event you could not yourself due to serious illness or significant injury. Also, a living will. A living will sounds like a will, but it's an entirely different document for an entirely different purpose. And a living will is used to put in writing your wishes regarding medical treatment. Most people will use a living will for end-of-life medical treatment guidance to specify in what situations they would or would not want heroic measures used to sustain life towards end of life. It gives the patient's wishes in writing so that the person's named as the agents, the actual decision makers under the healthcare power of attorney and mental health power of attorney, know the person's wishes and can overlay those to the circumstances in consultation with the medical doctors and act in accordance with the known wishes. The next document that everybody over age of 18 should have is financial power of attorney. So the financial power of attorney is important because it designates someone to handle your financial matters in the event you cannot yourself. So if you were ever incapacitated, or as I like to say, you are still with us, but you are not with it. for any period of time. And everybody gets it when I say it like that. The financial power of attorney simply allows somebody, again, you know, like in trust, to take over, handle your investments, your real estate, legal matters, business affairs, and take care of things until you are back on your feet again. That document is only in effect during your lifetime. And in Arizona, if you don't have a healthcare power of attorney and you're not able to make your own medical decisions, we do have the surrogate decision maker statute that names certain people related to you that can make your medical decisions. But there is no default in the law of somebody that can handle your financial matters if you become incapacitated and you did not already have a financial power of attorney in place. Then as attorneys, we have to go to court to get somebody installed through conservatorship. So financial powers of attorney are very important. But when most people think about estate planning, they automatically associate that with a will, which is commonly referred to as a last will and testament, or a trust, typically and most commonly a revocable trust. You may also hear the term living trust. I'm going to use the term revocable trust throughout our conversation today because it more typically explains, what you can do. Great question. Somebody says, would you say that these are also in the order of importance? Yes and no, honestly. It depends on what's happening, right? If you're incapacitated and you can't make your medical decisions or handle your financial matters, and you don't have these documents, we may end up in court during your lifetime. And so then you would have wished you had these documents. If you die and you don't have a proper will or your trust in place, we may also end up in court or have unforeseen circumstances happen. And we'll talk about that. So really, they are all important and all together create an estate plan. So normally you do them all at the same time as opposed to one now and then some later. Hopefully that helps to answer that question. And that is a great question. Thank you. So we're going to unpack what a will is, specifically, what it is and what it isn't. A will is a legal document. It's a written legal document that in general is going to outline your wishes regarding the distribution of your estate assets after your death. A will is not in effect during your lifetime. I can't tell you how many people I've met with over the years that when I ask them, do you have a power of attorney? They say, oh, yes, I have a will, and I've named somebody as executor of my estate. Two very different things, because a will is only in effect after somebody dies, and it only deals with the distribution of your estate to your heirs or your beneficiaries after you've died. A will is unique also in that it is the legal document that we use for you to designate who you would want to be appointed as the legal guardian. If you have minor children in Arizona, if you died, there's no surviving parent. Your children who are under the age of 18 will need a legal guardian appointed. So this is how you get to designate the persons you would want as guardian. Also in Arizona, we have a little bit of a unique statute that says if you are the parent of an adult incapacitated child, so if you had a child, let's say, who is 40 and they have a brain injury or a developmental disability, and for some reason they are not able to direct their own personal decisions, and you're their advocate, whether you've gone to court and become their legal guardian during their adulthood or not, you can designate in your will who you would want to be appointed as their guardian after your death if they are unmarried, an adult unmarried incapacitated child. So if that's relevant to you, you want to make sure you put those provisions in your last will and testament. Again, a will only takes effect after you die, and the will designate or nominate somebody to serve as personal representative, whether that's an individual like a relative or a friend, or a licensed fiduciary or bank and trust company, which is our professional businesses or entities that can serve. In Arizona, we use a gender neutral term, personal representative. That's the person or the entity that will be responsible for marshaling your assets paying the valid debts, and then distributing the remaining estate assets in accordance with the terms of the will. Most people are familiar, maybe more familiar with the terms executor or executrix. Executor is the older term used to describe a male performing these services. Executrix is the older term describing a woman performing these services as personal representative. That is what a will is. Let's talk about what a trust is. So a revocable trust, it is also a legal written document that is intended to create and hold and manage assets. There's three important parties to every revocable trust. The trustor is the person or persons creating this agreement. The trustee is the individual or entity that is managing the assets in the trust. They're the ones that have the investment decision, the check writing privileges. We call them a fiduciary. They have the fiduciary responsibilities to manage the assets owned by the trust. And the third important party is the beneficiary. So typically, if you are creating a revocable trust, you're going to be all three important parties, right? You're creating this agreement. You want to manage your assets that you're putting into the trust. So you will designate yourself as the current trustee. And you want to have the advantage of your assets during your lifetime. So you will be the current beneficiary. But after your life, you will designate other beneficiaries, meaning the persons that would inherit exactly the same way as you would under your will. A trust, it can be in effect during your lifetime. So sometimes that's why you will call these trusts, you'll see these trusts called living trusts, because they're established and they're valid during your lifetime. Or you can use a will to create a trust for somebody after your death to hold their inheritance that you are leaving them through your will. You can also create a trust for somebody you are leaving an inheritance to through your trust. When you're creating a trust for someone else after your death through a will or your trust, we call that a testamentary trust. But the type of trust we're going to be unpacking today, again, is a revocable trust that's in effect during your lifetime, and it's going to hold your assets for your benefit. There's several purposes to using a revocable trust. One is it avoids probate. We're going to talk more about that. It also provides for the management of your assets during your lifetime. If you were not able to be trustee because you had a serious illness or injury, you're not able to handle financial matters for some period of time, you will name in your trust a successor trustee to you, just like you would an agent under a power of attorney. That successor trustee will take over and manage the trust assets for your benefit while you're unable to yourself. And the trust will then distribute your trust assets after your death, similar to a will. So a trust functions very similarly to a combination of a financial power of attorney during your lifetime, if needed, and a will after your death. So there's some real differences between wills and trusts. The other interesting thing is Arizona is a community property state. So where each individual has to have their own will. We don't do combined husband-wife wills together. Each husband would have a will, wife would have a will. But because we are a community property state, a husband and wife or spouses, two spouses, can create a trust together and have a joint marital trust for the benefit of both spouses in the couple. If one spouse dies, the trust will say what happens then to those trust assets, and usually they stay in trust for the benefit of the survivor, and there can be some other options as well. And then when the second spouse dies, the trust will say what happens to all of the trust assets. So a married couple can have a combined joint trust in Arizona. And in fact, that's what most couples will do in Arizona. But they can also have separate trusts. So if each spouse has separate property and they don't want to put it into a combined trust, even though the assets can still say separate in the joint trust, they want to have separate trust to hold just their separate property. And maybe they want a one combined trust to hold combined community property assets. They can do that. So trust can be very flexible for married couples in particular. So we're going to talk about what are the similar purposes? What are the same purposes that both a will and a trust serve? They both designate someone to handle post-death or after-death administration. We call that person, again, a personal representative under the will. We call that individual a successor trustee under the trust. Different legal tools they're using, different names they're wearing, but they are doing the same job. They are both marshaling the assets, identifying and paying the valid debts, and then following the terms of either the will or the trust and distributing the assets according to that legal document's required terms. They both control the distribution of assets after death. So what do they control? The will controls the deceased individual's, I'm using my legal air quotes here, estate assets. The trust controls the distribution of the trust assets when the trustor has died. So what is in the estate and what is in the trust? An estate asset is a leftover asset. So what do I mean when I say a leftover asset? When somebody dies and in their name alone, they've got a piece of real estate, for example, or a brokerage account or a bank account. And that piece of real estate or those accounts are just in the name of the person who died. There's no surviving joint owner that would now own it by operation of survivorship. There's no beneficiary on that account. There's no pay on death or transfer on death designation on a bank or a brokerage account. There's no beneficiary deed on that piece of real estate. It's just in the name of the person, and it's not titled to a trust. So that asset was only in the name of the person, and now that asset is wondering, where do I go? Who owns me? That is the definition of an estate asset. They are assets that are not already told by operation of law, joint survivorship, beneficiary designation, or trust, right? Those are estate assets. So by contrast, what is a trust asset? A trust asset is any asset that is already titled to the trust when the trustor dies, or is paid directly to the trust by operation of law after the trustor dies. So for example, let's say the trustor had a life insurance policy and they stay the individual owner, but on the life insurance death beneficiary form, they designated their trust as the beneficiary. The trustee will claim the life insurance death benefit, put it into a trust account, and from there it will be distributed. So there are assets that are owned by the trust or paid to the trust at time of death of the trustor. So you can see different documents are only going to control the assets under their umbrella, estate or trust. That distinction is going to be important when we talk about probate versus non-probate in a minute. The advantage of both of these documents is that they can be amended while the person who created the will or created the trust is competent. You can change these documents. So if you decide later different people should inherit or different people should be in charge and have these responsibilities in handling the estate after you die or the trust estate after you die, you can make amendments to a trust or a codicil to a will. Same thing, different names. You're just updating the terms to reflect your current wishes. So somebody just posted a question in the Q&A. And the question is, so would anything that falls in the quote estate be subject to probate? The answer is yes. In Arizona, probate is required over an estate when the estate assets have more than $100,000 of equity in real property or more than $75,000 in other assets combined. So think vehicle, checking, savings, brokerage account, right? If those accounts or those assets were just in the name of the person who died and they're now in the estate because they were not in the trust, again, no surviving owner, no beneficiary, and we hit those thresholds of value, we have to submit the will to the court and go through the probate process. Here's why. We'll kind of unpack this a little bit. So And this kind of gets into the differences. How are a will and a trust different? A will goes into effect only after somebody's death. A trust is in effect during lifetime and post-death. But with a will, the assets may go through probate if the assets in the estate hit our thresholds. And here's why. A will sounds great. It names somebody to serve as personal representative, but that person cannot just take the decedent's death certificate and the will to the bank and say, the account holder has now passed. I'm the person named as PR. I need to open an estate account, get signing authority, and start paying bills. The bank is going to say, you have to come back when you have your, quote, letters of appointment. So the will names somebody, but that person has no legal authority to act on behalf of the estate until the court issues letters. Well, letters of appointment are what the court issues in a probate proceeding. If we have a will and we have, let's say, $30,000 in the bank account, because this will probably be the next question. What happens if the estate assets are below 100,000 in real estate or 75,000 combined in other assets, and we don't have to go to probate? How does it work then? If we're not required by law to go to probate, we can use what's called a small estate affidavit. The challenge with real property is we cannot collect real property from the decedent's estate to the heirs of that estate any sooner than 6 months. We have a 6-month waiting period before we can collect real estate. Well, with real estate, you usually have a mortgage. You want to change the locks on the property. You want to get it listed for sale. You want to clean it out. You know, there's things that need to happen with real property. So most families don't want to wait 6 months before they can change ownership from the decedent to the rightful heirs. So we end up opening probate anyway. So somebody, the personal representative can transact business related to that house sooner and protect that property from waste or dissipation. But on bank accounts, let's say there's $30,000 in checking and savings. We don't have to go to probate with those accounts, but we have to wait at least 30 days for the heirs to collect, or the devisees under the will to collect the asset from the bank. So sometimes because of wait periods, we'll end up opening probate anyway. There are some reasons we might choose to open probate even if we didn't have to by law. But yes, with a will, you can definitely end up in probate. And that's a big myth out there. People think, I have a will, I won't go through probate. It's not whether you have a will or not. A will names your preferred person to take care of the estate and designates who will inherit, but the process will be dictated based on the assets at the time the decedent died and their valuations and how they're titled. With a trust, by contrast, there's no probate required. Why is that? So when you have a revocable trust during your lifetime, you again, using my legal air quotes, you fund your trust. We retitle your real estate to your trust, your brokerage accounts to your trust. We want your checking and savings account to be paid directly to the trust by beneficiary designation, if not changed by ownership to your trust. We look at everything you own and we put it all in the trust, or we coordinate beneficiary designation so we don't end up with big assets outside of the trust in the estate to avoid probate. But the assets are titled to the trust. It's its own legal entity during your lifetime. So there's no change in ownership. And trust law gives your successor trustee automatically by law all the authority they need to do the job. They don't need a court order to vest them with the authority. They already have it. So that's why trusts are used to avoid the court probate process after somebody dies. With a will, wills, we tend to use just a simple last will and testament when it's more of a simple estate planning. It may be we've got one beneficiary or two beneficiaries, very simple assets, not a lot of complex family dynamics or no estate tax planning we need to do or unusual assets. You know, maybe a will will get the job done. A will get the assets from point A to point B, right? It will do that. It's just, what is that process going to look like? When we have more complex family issues, second marriages, minor children, disabled beneficiaries, beneficiaries with, you know, chronic drug and alcohol abuse or addictions, families that maybe don't always get along, estate tax issues, unusual assets, then usually a trust is going to be a better tool to use to address those planning considerations than a will. A will generally costs less. Attorneys generally charge less in legal fees to prepare an estate plan that just includes a will with the power of attorney and the medical directives, as opposed to a trust with all of the ancillary documents. So sometimes the initial cost is less to use a will plan as opposed to a trust estate plan. But on the back end, if we have to go through probate using a will-based plan rather than a trust-based plan, then it becomes more complicated, and usually probate is going to cost more than just a post-death trust administration. So it's almost a pay me now, pay me later issue on legal fees. The other issue with a will, and the big difference is, with a will, we often end up in probate. Probate means if any interested person files a notice of appearance and a demand for notice, they're entitled to see everything, right? The will, its terms and accounting, they're now really a party to the proceeding. Whereas a trust administration, when somebody dies, is private. By law, only the beneficiaries that are named are entitled to see a copy of the trust and accountings and what's going on with the assets. So for a lot of people, privacy is really important, and they would choose to use a trust and stay out of the probate court process for that reason. The other big difference is, again, a trust is valid during somebody's lifetime. So it's got some advantages there that a will doesn't have. With a trust, whoever the current trustee is has the sole authority to manage the assets of the trust for the benefit of the current beneficiary, which means if our trustor, the person who creates this trust, is the initial trustee, and then over time, at some point in the future, they start having some cognitive impairment. Let's say they are older and they develop dementia or Alzheimer's type dementia, or have some type of a cognitive impairment, where now they really could become the victim of financial exploitation. They are now a vulnerable adult, and they're still in charge of all of their investments under the trust. When a doctor puts in writing that they're no longer able to handle financial matters, that will remove them as trustee, and the person that they pre-named to succeed them as successor trustee can then take over. So a trust is a great tool, and we use it all the time in our elder law practice, so that somebody can protect themselves against potential future exploitation, because the person or the entity that they entrusted to step in when needed will be able to do that. And only the trustee can manage the assets title to the trust. So now if that vulnerable adult meets a new neighbor, and the new neighbor starts trying to talk that vulnerable adult out of money, and they go to the bank together, and the account is titled to the trust, and that vulnerable adult says, I want to pull $10,000 out of my trust account to give to my new best friend. True story. I've had that happen with a client family one time. The bank officer will literally have to say, I'm sorry, I can't release those funds to you. Your trustee will need to come in and help with that transaction. So you can see how a trust can be used to protect somebody against future potential vulnerability. Also, we find just in the practical day in and day out world, financial institutions prefer to work with successor trustees in managing the assets for someone who's become vulnerable and is no longer able to handle their own accounts. They're more cooperative when they're working with a successor trustee under a trust titled account or property, as opposed to an account or a piece of property titled to the individual who's now incapacitated, and an agent under a financial power of attorney is taken over. There's no reason under the law for that. It's just what we see happening in the real world. So if some of these advantages appeal to you on the trust side, a trust would make sense, as opposed to maybe using a will. That may be, some of the considerations that would help tip the scales to making the decision as whether you wanted to have a will-based estate plan versus a trust-based estate plan. When you have a trust, you will still have a will, by the way. but it's a different type of will. The type of will you have when you have a trust is known as a pour-over will. And that's supposed to mean P-O-U-R, not P-O-O-R. And the pour-over will literally says anything in my estate will be distributed to my trust. Well, why is that? Your trust has all the specifics, all of the individuals or charities that you want to leave your assets to after your death. Your trust has all the specifics. So your will does not mirror that. Your will is simply there as a safety net. Let's say you accidentally opened an account that you meant to put in your trust and you forgot and you passed away. Well, we want to make sure that that account, along with everything else, gets picked up and put into the trust. Again, however, if that account is worth more than $75,000, we still are going to have to probate your pour-over will. So that's why that funding of the trust is really important to still make sure we avoid probate. So what are the factors that you're going to consider in deciding whether a will-based estate plan versus a trust-based estate plan makes sense for you and your family? There's a series of questions that you can ask and you can work through with your attorney. The first question is, what does your estate consist of? What do you own? What are the types of assets and accounts? Is it real estate, personal property, bank accounts, brokerage accounts, retirement accounts, life insurance, right? There's a number of different ways to pass assets at death. One is through joint ownership. A will and a trust only control, again, what is in the estate or what is titled to the trust. So if you had a piece of real estate that you owned as with your spouse as community property with right of survivorship, or with a sibling as joint tenants with right of survivorship, when that deed says with right of survivorship, when one of you dies, the survivor inherits your half, right? That makes sense. You do not, however, want to put your kids on your real estate and make them a co-owner if the only reason is to avoid probate. You would use something called a beneficiary deed or a trust, and that's something you would walk through and all the considerations with your lawyer, your estate planning attorney. So personal property, cash accounts, brokerage accounts, you can designate on your bank accounts, pay on death designation, POD for short. Brokerage accounts, you can name TOD, transfer on death accounts. Those accounts go directly to your beneficiaries, but there are considerations, and we'll talk about those. Retirement account and life insurance are controlled by beneficiary designation. So all the value of your assets, the composite of your assets, how they're titled, you want to do a full inventory of that. Then what are your assets worth, right? Are we going to be over the $100,000 real estate equity threshold or the $75,000 asset threshold if we just use a will-based plan and you want to avoid probate? Well, then we should use a trust, right? How many beneficiaries you have? That could be a big factor. I can't tell you how many people I've talked to that say, I have 3 kids. I'm just going to name them all as direct beneficiaries on everything. Pay on death on my bank accounts to all 3 kids. Transfer on death on all my brokerage accounts to my kids. Same with life insurance, retirement, and I'll just do a beneficiary deed, and I'll just do a will-based plan. It'll all work out. Well, in the real world, here's what's going to happen. Each of your 3 children, if you do that, are going to receive 1/3 of every asset. But the bills still need to get paid. So are they actually going to be able to coordinate and communicate well enough and get along well enough at every single step of the way to cover the Visa credit card bill, the cell phone bill, the outstanding medical charges not covered by insurance? It's a lot of work that has to happen. And every time you add one more person in, even if they get along, you have time delays, geography challenges, communication issues. So you really have to think through, how is this going to work in a real world if I have a lot of beneficiaries? Maybe it's a lot smarter to put one person in charge who can collect all of the assets pay all of the debts, do a full accounting to everybody, have everybody bless it, and say, okay, now everybody's going to get the net because we know we took care of everything on the front side. So you're not putting all of these individuals in a position where they have to coordinate every single step of the way. I've just seen so many challenges for families, even families where everybody inheriting gets along. So, you know, how many beneficiaries you have, the age of your beneficiaries. Are they adults or are they minors? You know, if they're minors, you can't just name them on a beneficiary. They're going to, because if they're under the age of 18, they're not old enough to inherit outright and they'll end up under a court proceeding. So you want to make sure their share is going to go into a trust for them. There's all kinds of think about how many, who they are, their life issues as to what's the best way to strategize for them to inherit through a will or through a trust. And then what are your goals, right? I can generically say with confidence of over 25 years of doing this, drafting documents and also walking families through the process of handling an estate after somebody dies, whether we're doing it through trust administration or probate or non-probate transfers directly. If your goal is to make things as simple as possible on the person that you're going to entrust to do the work, and it is a big job, it takes a lot of time and a lot of detail. If your goal is to make things as simple as possible for the person that you name, you want to have the least amount in legal fees and costs for the whole process. Ease of administration. You want them to, you know, have an easier time of dealing with the financial institutions, the title companies, the brokers, the insurance agents, whoever they're dealing with in managing things. You want to avoid probate because you don't like the idea of things being public. You want things to be private. You don't like the idea of, you know, a court being involved. Then a trust is probably the way you're going to want to go, right? Trust gives all those upsides over a will. But if your goal is just, I just want to get my assets from point A to point B, I don't care if my estate goes through probate. I don't care if it costs a little bit of money. And I've had clients say that, and there's nothing wrong with that. There's, you know, estate planning is not a cookie cutter approach. Every family, every individual has unique goals, assets, objectives. You have to decide what makes sense for you. I have clients right now, they're a married couple. They're financially very, you know, solid, and they don't have a taxable estate, but they certainly have millions of dollars combined. They have no children, they have no grandchildren, the rest of their family doesn't need their money, and they're very philanthropically inclined, and they have a number of charities that they've donated to over the years that they've been involved with, and they're going to leave their entire estate to charity. So when I talk to them about their goals, they're like, we don't care. We're going to have a professional entity administer the estate. They're going to get paid to do it, and the charities are going to get what they get. We don't care about going through probate. Okay, that's a great example of somebody that might want a will-based estate plan that doesn't feel that they want or need a trust. I've had other clients, you know, a widow, she has one child. The one child is going to inherit everything. She owns one home, checking, savings, a brokerage account, a life insurance policy, and she's done a beneficiary deed on the house to avoid probate. She's named the daughter as beneficiary on all of the bank accounts, the life insurance. She's like, my one daughter is going to get it. She's one daughter is going to pay all the bills, keep anything that's left. I'm just going to do a will-based plan, right? Okay, that might make sense. That same lady, if she had early cognitive impairment, that diagnosis like a dementia and Alzheimer's that was expected to progress, well, she might want to trust, because at a certain point, she might really want to have her daughter be able to protect her if she became the victim of potential financial exploitation due to lack of capacity later, right? So there's all these factors that go into deciding whether you want to have a will-based or a trust-based plan. I will tell you, generally, most people, when they learn the differences, are probably going to pick to use a trust-based plan. So I've got some questions here that I'm going to answer. So feel free to populate here in the Q&A. First question is, have you experienced an issue having multiple beneficiaries and one of them being the successor trustee? Oh, sure. Right? If, let's say you've got 4 kids and they're all going to inherit equally, but you name one child as the successor trustee to handle the administration, to do the work, that one child is still fully accountable to the other 3, right? They're not going to inherit anymore because they're in charge. They may receive compensation if the trust allows them to be compensated for the time they're spending, and if they choose to receive compensation, but they're not going to inherit anymore. But they have to do a full accounting. So if the other 3, any one of the other 3 distrust that child, or maybe one of the other 3 has mental health issues, or just is not as astute in understanding this, they can complicate the administration and make it very difficult for the one child that is going to be in charge. If everybody gets along, everybody, when they get the full accounting, can understand what happens, believes the bills should have been paid, the tasks, performed were reasonable, etc., then it can work out. Having one beneficiary in charge, handling everything for multiple beneficiaries, that's typically what happens. You can actually have the reverse problem too, which is, let's say you've got 4 beneficiaries and you've named 2 of them as co-trustees, co-successor agents, or maybe you have 2 beneficiaries, and parents always want to be fair, right? You always want to be fair. And so it's like, I've got 2 kids, I'm going to name them both. They're both going to have to work together to do this. Well, that might not be a great approach either, because if you make them act together with all acts being unanimous as co-trustees or even as co-personal representatives, they both have to agree on everything. So what if your house is going to be listed? They both have to agree on the realtor. They both have to agree to counter offers, final offers, be at the signing to close on the sale of the property. Both be on the account, on the phone with the investment advisor if there's going to be a change in the investments on the brokerage account, right? Or selling the account or journaling the stocks out. It's just from the trust to the ultimate beneficiary. So by having 2 people as co-trustees, you can actually create issues. You really have to just understand the personalities of everybody. I will get a lot of questions from people about, who should I name as trustee or who should I name as personal representatives? And it's going to be who you think has the time and the talent to do the job. You don't pick the oldest person, the oldest family member because they're the oldest. You pick the person who's the best. If the kids all don't see eye to eye, you may have a great relationship with each of them, but they may not have a great relationship with each other. Sometimes naming a third-party professional, whether that's a bank and trust company or a licensed fiduciary, is the best thing you can do for your family. Because yes, that bank or that fiduciary, that professional is going to charge to do the job. But I will tell you right now, I can guarantee you that it will cost less in having a professional do the job than having everybody arguing about everything all the way along and all getting lawyers onboarded and having a difficult administration because there's lack of communication or distrust among the beneficiaries and the trustee. It's just better. It's a gift to the family to put a third party in charge. That way, the family may still like each other at the Thanksgiving table. And that's what you want, right? You want to leave a legacy that is positive and doesn't leave hard feelings. So selecting the trustee is a third-party trustee can sometimes be the best solution depending on the abilities, the skill set, the time, and the relationships between each other. Got another question here I'm going to try and answer. My parents have real estate, about $40,000 based on county assessor in another state. So outside of Arizona, this has made them financially and unapproved for Medicaid. Would a trust solve this? If so, what type of trust? So this is not an estate planning question per se. It is a Medicaid long-term care planning. And because we do that work, I can answer this question off the top of my head. No, for All-Tex Arizona long-term care system, All-Tex benefits, if you have out-of-state property, it is a countable asset. Even if it is your primary residence, it is not exempt. And there is no trust that is going to fix that unless the Medicaid applicant happens to be disabled and under the age of 65. We can use a first-party special needs trust, but that is not usually the case. And so no, there would be other fixes for that. So for the individual who posted that question, contact our office and we can walk you through what some of the options would specifically be. Another question is, would a will or trust be best if there's only one child? If we can name beneficiaries on all of the assets and avoid probate through beneficiary designation and still do a will, maybe just a will-based plan works, but again, there's some other factors to consider, depending on the value of the assets. If they are significant, a trust would probably be better to get more cooperation from the banks and the financial institutions, or if there's a potential of incapacity and vulnerability later on behalf of the parent, maybe a trust still makes sense in that case to protect the parent. You know, it's hard to give a boilerplate answer because every family dynamic is different. And so what's right for your neighbor, for your other family members with their nuclear family may be very different for yours. Great question. What is the process to establish a trust, wills, powers of attorney? I'm a lawyer, so I'm sure you all know, I'm going to say meet with an experienced estate planning attorney. This is not an area where you want to DIY this. You can go online, download forms. There are companies that purport to do that. There are individuals called licensed document preparers that are non-lawyers. They are not permitted by law to give you legal advice. You want to sit down with an estate planning attorney to go over your specific circumstance and get best recommendations. That attorney or their firm is then going to prepare the documents pursuant to your goals, objectives, the decisions that you make, and help you coordinate the whole thing. And, you know, think through all of the if-thens, all of the real world scenarios that can happen to put together the best comprehensive plan. So you definitely want to sit down with an attorney, go over your goals, objectives. They should be asking you for all of your family information. They should be asking you for all of your financial information. If they are not, you want to give that to them because you want to ask them a lot of questions. They need to have all the information to give you the best advice and create very thorough documents. Again, a will or a trust alone is not a complete estate plan. You want to have a will. If you're going to have a will-based estate plan, you're going to have a last will and testament, but you're also, again, going to have a financial power of attorney, healthcare, mental health power of attorney, and a living will. And you should probably also have a medical release. We always do HIPAA releases for our clients so that anybody named can talk to the client's medical providers and get information when you start making, you know, medical decisions by committee. It's very helpful if those on your quote committee and your family that you would want, like your kids or your spouse, to be able to talk to your doctor and get information, confirm appointments, etc., talk to the nurse in the hospital, that kind of thing. So probably a HIPAA release as well. If you are doing a trust-based estate plan, you're going to have a revocable trust. You're going to have a pour-over will. Remember, it's the kind of will that goes with that trust, but it is a separate legal document. You're going to have a durable financial power of attorney, and again, the set of medical directives, healthcare, mental health, power of attorneys, living will, and that HIPAA release. All of those things together is what your attorney should be preparing for you. Another question that I see is, if you have these documents and you've done them in another state, are they valid here in Arizona? And the quick answer is yes. As long as the wills and the trust and the other documents were valid under the originating home state, they are valid and they'll be recognized here. However, we have different medical directives in Arizona than many other states. In particular, we have a mental health power of attorney that is unique to Arizona. So your medical directives, I always have clients do new medical directives. Your durable financial power of attorney, if it's more than 5 years old, you want a new one anyway. It's getting stale dated according to banks, financial institutions, and title companies. They don't like to work with older documents. They like newer dated documents. Not that they're not invalid. It's just they will work more cooperatively with the agent if needed under a more freshly dated document. If you came from a state that used what's called a short form power of attorney, we don't like them here in Arizona. You want a very robust, very lengthy, complete, durable financial power of attorney here. Wills and trusts, if they say what you want, they accomplish your goals from another state, you might not need those updated here. But you should have them reviewed. Another common question that I get is, how often should I get my will and my trust and my estate plan reviewed or potentially updated? Our rule of thumb and general recommendation is every 3 to 5 years, unless you know you want to make a change. You should sit down again with your experienced estate planning attorney and do a quick review. And just make sure that your assets are still titled appropriately to be cohesive with the overall plan. The right people are designated. You still want the beneficiaries or the heirs that you have named to still inherit in the same fashion that you've got named. I can't tell you how many people I recently met with that are coming in with 15, 20-year-old or older estate planning documents, and they did them when their kids were under the age of 18, and now their kids have kids, right? We have very different people that they would want to be handling things than they did 15, 20 years ago. Different ways they would want their families to inherit 15, 20 years ago. So it is important that you do look at them more than every decade. I would say every 3 to 5 years is a good time for just a general review, unless something comes up. If there's a major life change, that should trigger a thought in your mind about maybe I should call my estate planning attorney and get a quick review. A divorce, a marriage, births in the family, deaths in the family, moves to other states. You've significantly changed your financial situation. Maybe you've inherited a lot of assets. Maybe you've won the Powerball, right? A lot of things can change. And so when you have those major life changes, that might be a good time for a tune-up on your estate plan. So we're just at time here. It's been just about an hour. If anybody has a last question, I think I've gotten to all of them now, but pop in a question here if you have one. We'll answer it in our final minutes. We do really appreciate your time and your interest in this subject matter. Estate planning oftentimes is something people put off. They feel like it's overwhelming. It involves lawyers. I get it. Nobody wants to go talk to an attorney. They think it's going to be too expensive. But all of those things are not necessarily true, right? The idea with having an estate plan is having a game plan. It's far better to have everything set up in advance of an illness, an accident, or worse, so the people you know, like, and trust will be able to assist you if needed with medical or financial matters, and the persons you intend are going to inherit in the way you want them to inherit, with a minimum amount of drama, cost, time delay, or tax. That is the goal of estate planning. So when you do estate planning, it's really a gift for not only those you care about, but those who care for you. It makes their job easier, and it allows you to take care of your family and leave a legacy and not kind of a mess. So that's the goal with estate planning. We really appreciate your time. And, we're here to help if you're in Arizona and you want a review of your estate plan, or you've got questions about estate planning, whether we're starting from scratch or we're starting from an existing plan. We can help review your documents. at any time to contact us. I think you all have our contact information. Just call the office or shoot us an email, and we'll be happy to help. So we hope you've enjoyed our presentation today, and have a great week.